The mechanics of estate planning in terms of how to orchestrate and complete the steps in order to make it happen can vary a lot from person to person. Generally speaking, when people first contact me, most have done some reading, have talked to friends, maybe have gone to some seminars, and have a general idea as to what perhaps needs to be done in order to put a plan together in terms of what documents are required. But the process is generally, for me at least, an initial meeting with a client, and we try to make it as convenient as we can. Whether that's a face-to-face meeting, whether that's a telephone meeting, maybe a video conference meeting, to assess what the needs are, go through questions and answers in terms of what goals and objectives a client wants to meet, how they want their estate to be handled in the event of their death or in the event of their incapacity, identifying persons that are going to be nominated in order to fill the shoes of the client if they do reach a point where they're not able to manage their own affairs or when they pass away. One of the questions in dealing with who should I choose sometimes is difficult. Most people kind of look at the concept of, number one, choosing their spouse first, but if their spouse is not able to do that for whatever reason, then most people look at their children typically in birth date order, chronologically speaking, oldest to youngest. I always ask the question, whether or not that person is responsible. How do they handle money? Do they make wise decisions? In terms of health care and maintenance, are they responsible to take care of physical needs and things like that? And in asking those questions, sometimes we discover that maybe just because it's the oldest child or the middle child, or even the child with whom that client has the best relationship, may not necessarily be the best choice, just simply because, not that they're a bad person for any reason, but they don't have the priority structure or the responsibility structure to make sure that they're making the right financial choices or the right personal or healthcare choices for the client. So it's important that we talk about those things. Sometimes clients get a little bit concerned in terms of choosing one child versus another, the concern being whether or not that will be offensive in some way to a child. And what I really try to emphasize to clients in that circumstance is that although there may be some concern with regard to choosing one child over another, especially if it's not in the traditional sense of being in chronological or date order, we have to make decisions that are best for the client, best for what the client's objectives are in making sure that things happen. The whole point of setting up a trust or a healthcare directive or a power of attorney is to avoid court, so that people don't end up in a situation where the judge is making decisions for them. And if we appoint people to a role where they may not be acting the most responsibly, it could be a situation where even though we've done the proper planning to avoid having people in court, they may end up in court anyway because somebody is making bad choices and not handling things in an appropriate way. So it's really critical. Sometimes we run into people that may not have anybody that is a good choice, maybe a widow or widower, and they have children. They have a great relationship with their kids, but they're not really the best people suited to make those decisions. So we probe and reach out. What other trusted family members may be there that can help them? Preferably younger people, nieces, nephews, if any. When we're dealing with financial situations, one of the things that we may talk about is having a professional fiduciary, a person who's hired in order to manage assets and estate resources, who is licensed and certified and has a bond for financial protection, so that we don't have as much of a concern about mismanagement of assets. So we go through those questions. Once those people are selected, and we talk about how they want things to be distributed. My process is I will draft an initial document, a trust, a power of attorney, a healthcare directive, maybe deeds, what we call funding documents, things like that, and we will send all of that out to the client because it's a lot to absorb and read. A minimal estate plan usually is probably around 100 to 120 pages of legal reading, which is not fun. And I like to make sure clients have enough time to be able to read it, make notes, write down questions, discuss. It gives us an opportunity to meet, go over their questions, ensure that my client and I are on the same page, that we're doing what it is that they've asked us to do. I understand completely what they want. They understand completely what I've done, so that there's no confusion or ambiguity. During that conversation, we may discover that we need to make some changes or revisions, in which case we'll redraft and continue the process of meeting and redrafting as much as is necessary to make sure that we are all on the same page in terms of what the goals and objectives are. In most cases, it's usually just a single draft, but sometimes it's longer. And sometimes, interestingly enough, I find that after having a very lengthy discussion about what to do, and maybe even taking time to think about what to do, and then drafting documents and sending them out, looking at a hard copy of a life summary really can sometimes feel very different than talking about it. And not commonly, but sometimes clients will read it, and then they will talk with me and say, I don't know that really what my initial thoughts are really what I want to do. And so the revision may simply involve doing something completely different or marginally different than what we originally intended. So I just want to make sure clients have an ample amount of time to process and digest. Once we're certain that we have done everything that the client wants, and they're clear on what we've drafted and I've drafted, then we get together and we'll sign final documents and implement the plan. So the turnaround time can really vary significantly. Some people may get it done in a week or two. I've had people take months. I've had clients take over a year to go through that process. Sometimes it's tough. It's really hard to think about these really unpleasant topics. It's really hard to think about what happens to me if I get sick. It's really hard to think about what happens to me or my things after I pass away, because you have a whole life history there. And emotionally, it can be very difficult to face those things, and sometimes people need some time to just really process that before they make the final step. But it is an important process to make sure that we don't have confusion or questions or minimize conflict for family members later. But again, turnaround time just varies. Sometimes it's fast. We have a handful of people are sometimes wait till the last minute. They know they're very ill. They have been told they have very little time by medical professionals, and they need something done really quickly. And in those circumstances, we have to sometimes take extraordinary measures, maybe meet in a facility, and make sure that we do what we need to do to get things done, because time is very precious, and there's very little left in order to get those things accomplished. But again, we do what we need to do in order to make sure we're accomplishing the goal, whether it's a long time or a short time.